This meeting is being recorded.
Okay, good morning. Am I muted? No, I'm good. Okay, good morning, everyone. Welcome to our August Clear Up the Chaos. I appreciate you joining us this morning and taking time out of your busy schedule. I know your time is valuable, so we're going to jump right in. We have an action-packed itinerary like usual, and I'm going to go ahead and pass things off. I have Kyle here and Amanda as well, and I'm not sure exactly who's presenting on what, but I'm going to hand things over to them to begin. Lots of great things to cover, and I have received some questions from our sign up on the website that we will address at the end as well. But if you have any questions throughout, please feel free to send those via the chat box, and I'd be happy to relay those to the ladies, and we can address those at the end. So thanks so much.
Good morning, everyone. The first topic we're going to touch on today is anticipated upcoming changes to the new Form I-9. We did kind of tease this topic a few months ago, so if it feels vaguely familiar, that's entirely fine. It's not you, it's me. What I'm going to show you today is a little bit more information, and we're going to spend a little bit more time on the sections and just have a few general reminders just about the Form I-9 in general, just some tips and tricks since we do a lot of auditing of these forms. So to start off, I am going to show you moment of truth. Can I share my screen successfully? There we go. So you guys are all probably pretty familiar with what a Form I-9 looks like. In some variation over the last 20, 25 years, it has been modified. The sections, the fonts, the layout have been a little bit different over the years, but it has roughly looked like this. Now, if you haven't seen or noticed, because it's really easy to miss, up here at the top is where you see expires on October 31st of this year. Now, just as a note of caution, that doesn't mean you're going to have to go in and redo any of your existing I-9s. There's no redoing of anything here. This would just mean that starting November 1st, there's going to be a new version of this form that you are going to have to begin using. Now, we don't know exactly what the new form is going to look like. But again, like we teased a few months ago, day to day, a little bit more information is being shared, but we probably won't officially see it until the end of October. And even then, it might even be early November. But the basics are going to remain the same, and that it's going to be broken down into multiple sections. So in its existing form, section 1 is the employee information and attestation form. So this is where the employees are completing most of this first day. And they are doing that by their first day of employment. So they can complete this page 1 beforehand, but they can also do it on day 1. And again, they need to complete each one of these sections unless they are being assisted by a translator or someone that's helping them prepare to read the document. So not a ton of changes are expected here in section 1, because this is basic identifying information, last name, first name. The biggest thing that you'll see is most likely going to be, which you may not be aware of, as it stands right now, every one of these boxes is supposed to be completed. So for example, other last names used, even if the individual has never changed their last name before, is never going to change their last name, you are supposed to put NA not applicable in this box. There shouldn't be any blanks on the basic information. And that is true throughout the entire document. So in its intended form, might be NAs all over page 1 and page 2. That is probably the number one error when we are auditing I-9s for companies that we run across. When I do the spreadsheet of errors to look for patterns, the missing NAs are obviously the easiest to overlook. Another change that might be coming here to this page 1 is down here where it asks about whether a preparer or a translator may have assisted the employee with this document or translated it for them. This is one of the areas we actually see a lot of unintentional errors as well. People will be quickly filling out section 1 and they may not read everything in gray, and they'll just run down and see signature and they'll sign and date it and complete it that way. Since this section, kind of this subsection of section 1, isn't used all that often, or at least not on every form, the prediction is going to be that this bottom area here will actually become a separate form. It would be like an addendum to the regular I-9. So there wouldn't have to be any unintended errors or any confusion about when you're supposed to complete this. It's also really easy to miss this. I did not use a preparer or translator box. So we expect to see this entire section to go away and be a separate form that you would use in those situations. Then moving on to page 2, again, a few more changes we are expected to see. Wow, this one's already changed a little bit. So a lot of you may have the version where section 3 here, re-verification and rehires, might be down here on your version. This is an electronic version versus a printed version, which is why it's separated. Again, often the same issue occurs because this is all on the same page. People are very quickly going through the sections and they'll accidentally sign and date down here, when really this is only for those situations where you may be rehiring an individual while their I-9 is still valid. Or if someone had temporary employment authorization and you needed to come in and re-verify, that's where you would do this here versus needing to have to do a whole separate form. That's in its current form. Again, the prediction and the information that we're seeing discussed online is that this could possibly also become its own form. Again, because it's so rarely used, that might be a bit too extreme, but it is pretty rarely used. It's also used incorrectly most often when it is used. So I would expect that preparer translator to become a separate page and this re-verification and rehires to be a separate page. A couple of quick things that are just reminders of note in here. Whereas section 1 was the employee completing it, and then in its current form, the preparer, the translator. Section 2 is the employer or authorized representative. So this is the person who sees the documents. And I'm catching myself there because it always used to be physically see the documents. And then, as many of you guys are probably aware, a couple of years ago, when many of us went remote, the Department of Homeland Security authorized capturing that live moment of seeing either the passport or the driver's license, Social Security online, whether it be through a initial new hire video conference or through them submitting that information to you via picture, and then you, after verifying it, you destroying that or following your normal protocols to maintain those documents. Let's say if you're an E-Verify employer. A couple of quick reminders just in general, going out a bit of our main topic area, but just because it's things that we see so often. The biggest thing I see on this page is employers will direct employees to bring in their driver's license and their Social Security card on the first day. Unless you need to see those for other purposes, so maybe driving is required for the job, or maybe you are an E-Verify employer and you do need to see the Social Security document, you are not supposed to dictate which documents come in. So there's a full list of list A, B, and C documents, and it's either one item from the list A. The thing that you would see the most commonly used here is a passport. And the idea is that document, so the passport, would not only show employment authorization, but the second part of that is it identifies the individual. So there's a picture and it would dictate employment authorization, versus list B and C documents, which may be your driver's license. It might be a state ID card. It might be a green card. There's a full page of acceptable documents that would be the identifying through the picture, and then there would be a separate employment authorization, say through a Social Security card or green card. Again, right now you have to be really careful to make sure that you fill out every box. Up here, it's not so commonly missed, but you may see it down here in the certification or in the re-verification or rehires. If something didn't apply to that individual, you would need to go ahead and go in and mark it with an NA. That, again, as I mentioned before, is something that we expect to change on this next version. There also is expected to be a link built in to these lists to the online version. Now, again, there's normally two versions. There's an online version like this, which I find really helpful because all of these little prompts that keep appearing that will remind you exactly what it's looking for. Or there's a normal version without these little question marks. That would be the one you would print if you're doing them on paper. We're expecting to see hyperlinks within the document so that the list A, B, or C would take you directly to Homeland Security's website, where it gives you more information about that. You know, if they present a document, or let's say you've never seen a visa or a green card, this link would take you right to the government page. That will show you pictures of what it should look like, things to look for, where the numbers that you were looking for to fill out issuing authority document number are. So it would just be a bit easier to navigate those instances where someone presents something for employment authorization or for their identity that you may have not seen before, and it's easy to question yourself whether or not it's valid. So again, just kind of a convenience piece there that would easily take you to those resources, because it is quite detailed online. They have not only what the current versions of even a driver's license or a state ID card, but then they also have pictures of those that might have been issued, let's say in the last 10 years, that could still be valid, but have not been updated and don't look quite the same as it does now. We also expect, just across the board, whether it's here at the very beginning, whether it's here in section 2 or the additional addendum documents, just easier, more simplified explanations and instructions. These are so tiny, I'm squinting even right now to look at them. And you do this probably so often that you probably are not going in here and really making sure that you read and understand what each section is exactly looking for. A lot of times we run into people not realizing that you can give the employee 3 business days to present these verification documents and identity documents. Now, page 1 still has to be completed by their first day, but if they come to work and realize they don't have, let's say they were planning on bringing the driver's license and Social Security card, but they thought they had it in their wallet and they don't. That's okay. They just need to bring it within those first 3 days. And then you would fill the date sections down here accordingly. So first day of employment would still be the day that the employee completed this, or their first day if they did that beforehand. But when you actually inspect the documents or view the documents, you use that date down here under the authorized representative section. And I mentioned this a bit before and then went off on a tangent, but We have been really used to being able to view identifying documents either through Zoom, just like this, or webinars over the last 2.5 years. Currently, that waiver to not have to inspect those in person is set to expire also on October 31st. Now, every expiration date mandating that businesses have to go back to seeing these in person has been extended during the pandemic. So we don't know if that will continue, but it is something to also bear in mind if that were to change, that you can't necessarily just have a picture sent to you or have someone else check the document. And then the last big thing that I would really just kind of have a side note here to make sure everyone knows and understands is the person that actually is either physically reviewing the documentation and IDs, or that right now, if they're doing it over webcam, is the individual that needs to fill out this signature and attestation certification section. So it can't be one person viewing it in the field and then sending the information back to someone in the office. It should be finding a way to either train the individual supervisor in the field to be able to assist with this document, or right now it could be zooming into who's ever handling this within your office or supervisor so that they can actually complete this section and certify that they have seen the documents to the best of one's knowledge. They are authentic. They don't expect you to be sleuths or experts, but they do expect that it appears to be a valid document to the best of your knowledge. And again, there's a bit more information on that when you go to the website. I haven't heard that it might link that information and certification, but that would be really helpful and handy, just like A, B, and C. And my final point here, again, just as a reminder, would be please be aware that if you are the individual responsible for completing this section and certifying this information, that you viewed those documents, that notice it is not asking for your employer's name, it is asking for your name. And you personally, as the individual responsible, could, as this certification warning says, could possibly either be found guilty of perjury. You could also incur individual fines, not just the company, but you. So if it's your job to finalize this document, please be aware of that and of the procedures and the protocols and expectations so that you are not certifying something that you haven't actually seen before. As we get closer to October 31st, which goodness is just not very far away anymore, we expect to have more information on this. Like I said, I bet it's the end of October, maybe even into the very beginning of November, but we'll have confirmed information, since right now we're really just going off of what we've seen posted online, open for comment, and HR individuals' insights based on previous years' responses and information we've received. So I'm going to wrap up or what to expect on the next I-9 document. And for a moment, I'm going to pass it over to Kyle, and I'll see you guys in a minute.
Thanks, Amanda. So it's been a while since we've discussed COVID, and we wanted to kind of give an overview of how to navigate COVID right now in today's workforce. With school almost back in session and the winter months approaching, we thought it might be a good time to just review some of the procedures and share some of the latest news that could affect employers. Just last month, the EEOC issued new guidance for workplace COVID testing. So at the height of the pandemic, the EEOC had originally taken the stance that all on-site COVID testing for employees was legal across the board. COVID was considered a direct threat. So direct threat means it's a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. So by declaring COVID a direct threat, the EEOC triggered expanded rights for employers to reduce or eliminate that threat. This is why employers are able to ask if employees have COVID symptoms, or if they've been tested, and it allows them to administer the tests on site. Now, the EEOC is saying that employers will have to prove that testing employees is a business necessity. Factors that could be considered a necessity include community transmission, workers' vaccination status, and then certain working conditions. Not all workplaces present the same risk. So an employee working alone in an isolated location does not pose the same threat as someone who might work at a restaurant on a busy Friday night. It's also important to note that any questions asked to an employee any questions that you ask to the employee are related directly to COVID and does not run the risk of an employee potentially disclosing protected information due to the inquiry. Employers have to be really careful that they do not violate any ADA laws and accidentally have that disclosure of personal information. They also issued some guidance on testing potential employees, so applicants. Employers are allowed to test potential employees as long as there is a policy and that is uniformly applied. And employers may rescind the job offer if the employee tests positive, if it is a necessity for the employee to start immediately, and a necessity in person. So if it was a remote position or they could do any of the job remotely, then that would not qualify as a reason to rescind the job offer. So they have to test positive, they have to be needed right away, and it has to be in person for employers to rescind that job offer. Kind of transitioning a little bit to vaccine cards. So the last few months saw many companies officially returning to the office. 41% of employers have a vaccine mandate or testing requirement in place currently. Now that more people are coming into the office, employers are experiencing a higher volume of vaccine card fraud. The fine for fake vaccine cards can range up to $5,000 and can result in up to 5 years of imprisonment. If your company does have a policy requiring vaccines and you suspect that some might be fraudulent, there are some specific things you can look for. The first would be the absence of the manufacturer lot number, date, and the identification of the vaccine provider. So that would be the first thing you look for. If there are any misspellings, if the dates are inconsistent for when they got each round of the vaccine, if you don't recognize the name of a manufacturer or provider, if the paper is super thin rather than a card that appears to be cut with scissors, a card that has been fully printed instead of at least partially handwritten. If your company does have a policy requiring vaccinations, it also might be a good idea to update the policy with the possible consequences of presenting a fake vaccine card to you. So what happens these days if your employee tests positive? So with more people returning to the office and a rise in COVID cases, what is the current protocol if an employee tests positive? The CDC recommends the following, and I promise you there's a reason I'm going through every one of them, but if someone is unvaccinated and believes they're exposed, the CDC recommends 5 days of quarantine after the last close contact with a person they might have been exposed to. If they are vaccinated and exposed, no quarantine is necessary unless symptoms start to develop, and then they should just get tested to see if they test positive. If the person does test positive for COVID, isolation is recommended for 5 days. If the person presents symptoms, if their person is presenting symptoms, and the 5 full days ends and the individual was able to be fever-free for at least 24 hours, that should suffice. If there are no symptoms about a positive test, they should isolate for 5 days. For those getting very sick or with weakened immune systems, the CDC recommends 10 days of isolation. And the reason I listed all of that was because OSHA has been following the guidance of the CDC on isolation and quarantine very closely. So we suggest employers do the same and follow the CDC's recommendations, because it is possible that OSHA could conclude the failure to comply with CDC guidelines could violate OSHA's general duty clause, which protects employees from hazards that might exist in the workplace. In addition, an employee could bring a personal injury claim if the individual contracts COVID at work due to close contact with an employee who should have been out based on the CDC guidelines. Failure to comply with the guidelines could also be used against an employer in a case where a non-employee, so customer or a client, contracts COVID and becomes very sick or passes away due to the non-compliance with the CDC guidelines. So that's just some of the most recent regulations that we have been reading up on for COVID. I'm sure there is always more to talk about, but for now, I'm going to pass it back to Amanda.
Thanks, Kyle. So we're also going to switch gears entirely here again and talk a little bit about non-compete agreements, especially under the current administration. I feel like, about 9 months to a year, possibly even longer, time is fluid since we've been in this pandemic. We've heard a lot of information about the possibility that non-competes could be just outlawed almost across the board. And there's been a lot of articles and concerns about that. That to date has still not happened, but we wanted to touch base on some of the specifics here in Texas and some of the cautionary things that you might want to start thinking about should some version of this policy move through where you weren't able to use employment agreements, covenant statements, conflict of interest, any sort of non-compete type agreement. So currently in Texas, you can ask that employees fill out a non-compete agreement. It does have to be a very clearly written agreement with contractual limitations listed within it. And there should be clear policy guidelines. If you are going to use some sort of non-compete or conflict of interest, trade secrets, covenant agreement, anything along that lines, you do want to make sure that you have an attorney review it before you use it. There are quite a few online that are free and available, but you really want to make sure that is checked out by somebody working in Texas or in your state to make sure that it applies to all of the recent laws. Kind of going the opposite direction, a covenant is only enforceable in Texas if it is part of an otherwise enforceable agreement. So it would be part of the employment agreement. It might be part of a non-compete confidentiality policy. Here's the key parts. There has to be limitations to the time, the geographical area, and the scope of the activity that's prohibited. And we'll touch base a little bit more on that when I tell you what might be coming. But the idea, according to the courts here in Texas, is that these sorts of policies are actually supposed to promote competition and not limit it. So when you are either drafting or reading through different non-compete agreements, that's something that you want to keep in mind, that it's more about protecting your proprietary information than hampering the employee from moving forward and being successful. And just making sure it's written and with that intent and is very clear. So that's where we stand right now in Texas, at least from a very high level. What I would caution you to be aware of, especially if you have employees working in other states, is that many states are starting to have their own rules or tighten up their rules on non-competes. This came up, before even the last change in administration. But again, with the initial expectation that something might go out at the federal level, many states have gone in and since shored up their policies. So whether it be here in Texas and you're thinking about the future, or if you have individuals that either live or work in other states, here's a few things you just want to be aware of and think about when looking at the policy and the agreements with those individuals. So in some states, you have to have been an employee for at least 2 years. Now, I'm going to say that and then follow up with, it also may require you in that state to present it on the employee's first day. So you might present a non-compete on the first day, but in the nuances and fine print, it might say that it's not enforceable until the individual has been employed with the company for 2 years. Again, these are state specific. It's not applicable to Texas at this time, but it's something to think about. Other states, or possibly Texas and others that we work in the future, limit the non-competes to individuals that are high earners. So then those at a certain salary threshold versus it applying to every entry level or every other employee that may not be privy to the same confidential information. Again, as I just mentioned, some states require that the non-compete is presented on the first day, even if it wouldn't technically kick in until year 2. The exception to that is generally severance agreements. If you're entering into some sort of severance agreement that includes either language about non-compete, or if it is a separate non-compete document that you ask them to sign off on with severance or as a expectation of signing the severance agreement, you could possibly introduce a non-compete at that point versus having to have done it on the first day of employment. Again, I'm giving a really general overview here. So it's possible that you really need to get into the weeds or talk to an attorney if you're looking both at a severance agreement and at the non-competes. You know, we're happy to help to the extent that we can if you have questions, of course. But sometimes with areas such as this, I just want to warn you up front that a lot of times we do have to say, you know, it would be best if you spoke to an attorney to finalize this. But a bit more of the nuts and bolts of non-compete agreements. Again, employee might have to be there for 2 years. The agreement often can only then apply for the next 2 years. So let's say the individual worked for you for 5 years. So, and you're in a state where they had to be working for you for 2 years before it was applicable. So then they leave at year 5. It would be essentially year 7 or 7 years from when they started would be the extent that it could be valid. So only 2 years after they leave your employment is generally what most states require. It also can't be overly broad. So it can't be, you work in advertising, for example, it can't be you can never work in advertising for the next 2 years anywhere in the country. It has to very specifically notate, again, not only the duration of the agreement, but generally you define it a geographic area. If I could get that sentence out, I apologize. There has to be a defined geographical area that applies to you. So sometimes you'll see that within a certain number of miles, or it might be, you know, within a city, depending on the size as well. Now, again, we're getting a little bit more into the technicalities as to when that may or may not be valid. So, but know that it can't just be a blanket statement. You could never work for another advertising company. It needs to say something about a direct competition or why it might be a direct competition if it's in the same areas. Just as a hint and a tip, most states will encourage you to keep a digital copy of the record. And the idea behind that is if you still have either paper employment files, or if maybe you're electronic in all other areas, but you just have non-competes or severance agreements in an old filing cabinet, just that is not as secure for long-term storage, that something could happen to that file cabinet. There could be a flood, it could be broken, it could be moved and misplaced, and having a digital copy of that is just more practical and safer for the business overall. And then the last big key point that you'll want to make sure that you're aware of here in Texas or in other states is that the non-compete is not necessarily part of the handbook. Now, you might have some language in your handbook that touches on confidentiality or proprietary information, but the actual non-compete document is part of an employment agreement, and that is separate from your handbook. In fact, you want it to be separate from your handbook. So you might have some policy or some mention of some things, but the actual agreement itself shouldn't be in your handbook. A lot of times what you'll see in addition to those geographical limitations is language that says that individual employees can't take their current customers with them. Sometimes it even includes soliciting other employees. And a lot of times with this being so digital, that's really easy for companies to track if someone's updating their profile on LinkedIn. So just be aware of that and whether or not that's applicable. Really the key takeaway is if you are going to move forward with any sort of non-compete, go back and whether it be you as the decision maker or your executive or HR team, and really examine what the intent of the document is. Don't just have a generic one that you printed from online if it's not going to be something you're ever going to enforce, or if it doesn't really apply to your industry. It should be tailored, again, to your area, to your industry, to the length of employment and the stipulations in your state. But again, if we have a lot of documents that the employee is signing and they never get enforced, or even worse, if they get enforced inconsistently, again, you're just opening yourself up for discrimination claims and then truly watering down the process and your policies overall by just adding more for the sake of having it or checking it off of a list. So just a few things to keep in mind. And again, it does change state to state. So if you have individuals working outside the state, you'll want to check with the local regulations or state regulations. We don't have much more information as to whether this could come through at a federal level. Every few months we see it announced that it's coming. From what I could find and recent articles and research online from this summer, most of the analysts that are writing about the situation don't actually think that it might get pushed through at the federal level. But again, the prediction is that more and more states might come in and add laws and rules about this and restricted covenants and things like that. So things to keep in mind there. And then with that, we're going to pass it back to Kyle to talk about recruiting.
Thank you. So if you ask anyone in HR right now what our biggest challenge is at the moment, odds are we will all say recruiting top talent. Could be wrong, but I know that people on this call would probably all agree. So we wanted to share some of the recruiting process that we use at Ironwood in the hopes that it would help you if you're trying to fill some key roles at your organization. The very first step that we do when we're trying to fill a position is craft a very intricate job description. So a job description will summarize the essential responsibilities, activities, qualifications, and skills needed for that role. It might specify who that person reports to as well. And a very effective job description will provide enough detail for the candidates to determine if they're qualified for the position themselves. Not only that, but according to Indeed, 52% of job seekers say the quality of the job description is very or extremely influential on their decision to apply for a job. It really helps to make your job title specific. Targeted job titles are more effective than generic ones traditionally. And then after you have filled out that very in-depth job description, you can move to the job posting, and that that's getting it on whatever resource that you use. And I'll go over some on the next slide. But on the job posting, it should be the majority of things on the job description, but it should also include important company details like your mission, your culture, and any benefits provided to the employees. We really utilize the job posting to kind of show who we are and show what our mission is. And during most interviews, it's an easy way to connect with the candidates because they have already read up about it, and it just says a lot about who we are, just easier talking points. And I think it does a big difference in how many candidates we're able to get at times, because you don't see it in every job posting, but it definitely, you remember it when you do see it. We also advocate for putting salary and any benefits on the job posting. The market is just really difficult for the majority of people to fill their roles right now. And if people don't see the salaries or the hourly or the benefits, they are more than likely to skip on to the next one that does show it, because there's so many options out there for them and so many different roles with tons of different benefits that they have been looking for. So if you have any special benefits, especially, we suggest putting that in there. If you do unlimited PTO or flexible hours, maybe office snacks, tuition reimbursement. One of the really popular ones right now is a dog-friendly office. Those are some of the different benefits you can add on to the job posting because you're really trying to sell yourself. And those are some tips on how to make yours extremely memorable. And so we also wanted to go over different resources that we use. So we use the popular ones like LinkedIn and Indeed. We also have used Applicant Pro and Glassdoor, Monster Jobs. We have an HRIS system that we also can utilize, and it will post to a variety of different sites for us with one click. So if you utilize an HRIS system at your company, look into that if you did not know it might have that capability. You can also have job fairs. We have been recruiting for a lot of CDL drivers lately, and we realized that we weren't getting as many applicants as we typically do for other roles. And one of our team members suggested, Facebook and Craigslist. And that's not necessarily the top, 5 recruiting resources that any recruiter would tell you to go to. Craigslist, I wasn't sure it still did job postings, but they do. And we got applicants far faster that way. The Facebook groups have been instrumental in getting tons of people to give us a call. So you just have to think about the role you're trying to fill and use those resources to your advantage. And we are always happy to help give you some examples of what might be a better avenue than LinkedIn rather than Facebook. Or we also have been looking into using like specialized sites. So things that are created solely to fill roles in specific industries like trucking, like the one that we are doing at the moment. After you get your job posted, then you go through the application selection. Our biggest recommendation here is to do it quickly. You'll lose applicants overnight or within a couple hours. Sometimes it seems we'll try and schedule something and they've already been offered a job and they're already off market. So when you get to the stage of actually getting those applications, then that is really a time to drill down and make sure that you're going through all of them and responding in the appropriate amount of time, or unfortunately you might lose them because it really is that hard out there sometimes. So we also utilize something called Calendly, which has been really helpful for us if we have a ton of different people apply, or we have done a different interviews to schedule. It is a scheduling tool that you can send the links to the different applicants that you would like to set up an interview with, and it lets them schedule right on your calendar if you utilize a virtual calendar. And it has saved us probably 10 hours a week just not having to make those calls and set up those interviews. So if you have a large volume that you're trying to get through, or a large number of different jobs, then highly recommend using Calendly if you haven't. And then when we go to the interview process, we are a remote company, so it's a little different, but we have 3 interviews. that could be a little bit much for some positions and some different organizations. But the way that we kind of set it up is we have a very quick initial phone screen where we just get those basic questions out of the way and make sure that it would be a good person to pass on to the next round. And like, if they can't do travel and travel is required, then that's kind of an easy decision. If they're not within the salary range, then we want to make sure that we aren't sending them on to the next round thinking maybe they can get a higher salary when it's just not possible. So we try and be very candid and get those harder questions kind of out of the way. Because we use the second interview, which is usually our whole HR department. And that's where we ask those more intricate questions. And when we move them on to the final interview, if we decide to have a third one, that's our whole team interview and all 17, 18 of us right now. And that's mostly just so we can get a culture fit. And so they can see the company that they'd be coming into and making sure all the personalities fit. And they kind of just get to see who we are as a company. And it might be a little intimidating, but they actually genuinely like it for the most part. So they say. A couple things that we just like to highlight is to make sure when you are crafting those different questions for your interviews, because we craft all of our questions beforehand, and if it's more than one person on a interview, then we will divvy up the questions. But we always know that the questions that we are asking the candidates are acceptable. So the couple of questions that you are not supposed to ask are things like, how old are you? Are you married or living with a partner? Are you pregnant? Do you foresee any problems with childcare? Do you have any responsibilities that might prevent you from meeting the requirements of this position? Ethnicity, where their family's from? Are you religious? Are you a Republican or a Democrat? Do you have any disabilities? Those are just a handful of questions that, without knowing for sure that someone would just kind of go off book, that's why we like to write our questions down beforehand. The other method of questions that we use are open-ended questions, so that makes sure to get the candidate actually talking. So if it's not a lot of yes and no, and you can actually start having a real conversation, a candid conversation with them. You can also use hypothetical questions, situational. So if something really crazy happened at your work, the week before, you can say, how would you navigate that if you were in our shoes, and kind of just see how they think on their feet and see how their instincts are and if they would be a good fit for whatever necessities were in that role. So after we go through our interviews, we always make sure that we explain, the next steps to them as well, and make sure that we always call them at every step of the interview, so they always know where they stand. We really do our best to respond to those people and let them know either way where they are in the process of the interview, because no one likes to just be waiting by the phone. So we try and contact every single person and make sure that we let them know if they're moving on or if we had to go another way. But when you get to the actual, you decided to hire that person, you've had that third interview, by that time it almost feels like it's been a little bit too long of a process already, especially with how many offers people are getting right now. So our biggest recommendation is, when don't hesitate, give them a call, give them their offer letter as soon as you possibly can, give them a reasonable amount of time. Sometimes we give them up to 14 days to consider the offer, and then we might have to move on. But the faster the better is, I guess, the best advice that we could give people right now. Don't wait too long. But that is all I have on recruiting, and I think that's all, unless anyone has questions.
Thanks so much, Kyle and Amanda. Always great information that y'all share with us. I did receive a couple questions that I was going to bring to the table. Amanda, I have received a question about if you can provide the list of the updated rules by the CDC for COVID. If you can send that to me, I can send that in my follow-up email to all the participants. And then I also received a question not related to any of the topics per se that we talked about this morning, but when will the Department of Labor be issuing a new threshold for exempt personnel? And how much is it anticipated to be? Do you have any information on that that you could share with us?
Hopefully, my power went out. It was nice of the power to go out. So if y'all lose me, that's why. We're just on the phone internet right now. Honestly, we were expecting those updated exemption standards back in May. We thought June the latest, and we have still not gotten anything official. When this went through a few years ago, the last time they raised the salary and the job duties requirements, it did go back and forth for quite some time, for more than a year. But any time now is really the answer. As we said, we really expected to have it May, June at the latest. And again, we don't know exactly what they're going to put out as far as the exact salary requirements. What we've read and we've chatted about it again, like 6 months ago, because we thought it was coming soon, is we expect that threshold to be $49,000, $50,000. I've seen reports of much higher, and I've seen reports that there will be no changes, but it seems to be that 48, 49, 50 number is where we're estimating it's going to land and be a number that everyone agrees with, or at least tolerates, versus a huge jump. So not a lot of concrete information yet, but hopefully we might know more by even this meeting next month.
That would be great. Absolutely. Well, that's all the questions I received. If I receive any additional questions following this webinar, I will relay those and provide you with their information. Just a friendly reminder, this does take place the second Tuesday of every month. So save the date for September 13th. I can't believe we are moving so quickly through this year, but save the date and be on the lookout for a follow-up email with those links that you requested. And as always, if anything, comes to the table, feel free to send that to me or send it directly to the Ironwood team if you have completed the agreement. If you haven't completed the agreement, I always include that in the follow-up email. So feel free to complete that and send that back. And then you have access to these wonderful ladies all the time, and you don't have to go through me. So keep that in mind, and I do appreciate your time, and I hope you'll have a great rest of August and a great start to the school year for your kiddos, and I will be seeing you next month. Thanks, ladies.
Bye, guys. Thank you.
Bye. Bye.